Hi, everyone, and welcome. If you're having problems with the audio or having problems hearing me, put something in the chat, or if there are any issues that come up. My name is Amy Berquist, and I'm recording this training so that if some of your colleagues are not able to attend, they'll be able to see the video later on. If you don't want to be seen, feel free to turn off your camera. But we'll be sharing this sort of internally among our pro bono team. So welcome to our training on reporting to UN treaty bodies on the death penalty. We have a bunch of reports that are due in January, and now is the time to get busy and cranking away on those reports. And we're really thankful to all of you and your firms for your support for this very important advocacy to push for abolition of the death penalty worldwide. We have a lot to cover, so I'm going to figure out how to advance my slides here. So this is what we have on our agenda. I'll give a brief overview of UN human rights mechanisms and of death penalty issues that you might look out for in your reports. Then we'll talk about writing UN reports. There are two general categories for these treaty body reports at the list of issues stage, and then alternative or shadow reports. Then we'll talk about some general principles applicable to all of the reports that you're working on, and wrap up with, I hope, time for questions. First, if you're not familiar with the Advocates for Human Rights, we work to implement international human rights standards to promote civil society and reinforce the rule of law. We typically do so in partnership with partner organizations around the world, and on our death penalty advocacy, that's typically members of the World Coalition Against the Death Penalty, an organization we've been a member of for many years. And this kind of our added value to the coalition is helping our coalition partners engage in advocacy with the United Nations in collaboration with pro bono attorneys who help us do that work. One of the things that we bring to the equation is what's called special consultative status. This is a special status with the United Nations that non-governmental organizations like the Advocates have that gives us a little bit more access to UN mechanisms, and we help our partner organizations leverage our access so that they can take the floor of the Human Rights Council, for example, and get more opportunities for advocacy than they would have without sort of sharing our consultative status. So it's really a win-win in our opinion for our advocacy. Sort of the underlying theory behind our advocacy at the United Nations is connecting the global and the local. We have our local partners that are pushing for social change, specifically in this case for abolition of the death penalty. And they are working to press their governments to move in that direction. Those partner organizations and their constituents and the people with lived experience, they share information with the international human rights mechanisms. That's what you're helping them do right now, is get that on the ground information into the hands of people in power at the United Nations, the experts at the United Nations. And then those experts in turn use their influence to press the governments in those countries to move toward abolition of the death penalty. So it's this virtuous cycle of exchange of information and exchange of advocacy that we help facilitate in our role at the Advocates for Human Rights. So a little bit of an overview of the UN human rights mechanisms. There are a lot of different mechanisms that exist, so I want you to be aware that there's more to it than just what you're focusing on for your project, but what we're going to be focusing on are the treaty monitoring bodies. These are typically called committees, and they are tied to work on a particular human rights treaty. So jumping into treaty-based mechanisms, the brighter green treaty-based mechanisms are the ones we're doing reports for that are due in January that some of you are working on. But be aware that there are other human rights treaties as well that just the deadlines didn't coincide or the issues don't coincide, but there are 9 core human rights treaties. Each one has its own treaty-based mechanism or committee that's responsible for sort of overseeing compliance with the treaty. And sort of that's the overall world of human rights treaty bodies and advocacy opportunities with them. So in terms of all of our pro bono teams, we have 13, if I count correctly, 13 different pro bono teams working on 13 different reports. And this is just for our death penalty advocacy with January deadlines. We also have pro bono teams doing work on LGBTIQ+ rights and some other human rights issues as well. So we are very busy here at the Advocates for Human Rights. But this should give you a sense of the different treaty bodies we're focusing on, whether the reports are at the list of issues stage. stage, that's that middle column, or whether it's at the alternative report or shadow report stage, that's the right-hand column. But this, if I've captured it correctly, should give us what the countries are that are our targets and the law firms that are taking the lead on the pro bono reporting for those particular countries. If I have a mistake here, shoot me an email or shoot my colleague Teresa Dykoszek an email it, and we'll get things sorted out. But this should be, I think, where we have everyone assigned. And if you didn't know your assignment, pay attention to this. This will be relevant going forward, which particular treaty body your advocacy is focusing on, and whether you're focusing on that advocacy at the list of issues LOI stage or at the alternative report or shadow report stage. That will be important for understanding when you should pay particular attention as I'm talking today. I'm going to do a really quick overview of the particular treaties. The first treaty body we're going to talk about advocacy with is the Human Rights Committee, and that Human Rights Committee is responsible for overseeing countries' compliance with the International Covenant on Civil and Political Rights. And here you can see it's very widely ratified treaty, has 173 state parties. So there's a lot of buy-in for the applicability of this particular treaty, which means also that this treaty body is very busy. It has to review each country's compliance with the treaty, and that involves a lot of work. Relevant language in that particular treaty on civil and political rights is in Article 6. And I say I'm going to give a really brief overview of the relevant language in each particular treaty. You don't have to, and you should not in your reports be doing a deep dive interpretation of the language of the treaty. Your audience, the treaty body experts, they know this language, they understand the treaty very well, and we don't need to sort of preach to them about what the treaty body language, what the treaty language means. This is more for your background, so you understand the framework, sort of the mindset of your audience. This is the way they understand the human rights issues that are concerned. So Article 6 concerns the right to life in the Covenant on Civil and Political Rights. And most important in the first paragraph is that no one shall be arbitrarily deprived of their life. And so it's that arbitrary deprivation of life in the context of the death penalty that's the relevant human rights violation. Subparagraph 2 also says that if a country has the death penalty, it should be imposed only for the most serious crimes. And the experts on this committee have stated that the most serious crimes, what that means is it's a killing. It's a crime involving a killing. It's an intentional killing committed by the person who is potentially subject to the death penalty. So an intentional killing committed by the person to be sentenced to death. So that's another limitation. Subparagraph 4 says that you have the right to seek a pardon or commutation of your sentence. And then subparagraph 5, no death penalty for offenses committed when a person is under the age of 18, and no death penalty carried out, no executions of pregnant women. State party obligations under this covenant, non-discrimination is an important part of all of these human rights treaties. In this particular treaty, it falls under Articles 2, 3, and 26. There's also a prohibition against torture and cruel, inhuman, and degrading treatment in this particular treaty. There's also language about the right to due process, the right to a fair trial, which is highly relevant in capital proceedings, and also detention conditions. We'll look at the conditions of detention for people under sentence of death. And freedom of expression and association can also be relevant in some countries where, for example, lawyers representing people in capital cases can be subject to persecution, can be harassed by authorities, or human rights defenders or non-governmental organizations speaking out against the death penalty can face restrictions on their activities or persecution as well. So keep an eye out for how different issues might connect to the death penalty as you're doing your research. Next treaty we're going to do a brief overview of is the International Covenant on Economic, Social, and Cultural Rights. Not quite as widely ratified, but pretty widely ratified with 171 state parties. And this is one where it's a little bit trickier to connect to the death penalty directly. So we've done some advocacy with this treaty body under this convention, under this treaty, with not as much success. We've had some success, but it's more limited because the nature of this treaty kind of excludes things relating to a criminal legal system, excludes things relating to imprisonment, excludes things relating to sort of crime and punishment and all of that. So we have had some inroads, but it's a much narrower fit for our death penalty issues. Some of the things that are important under this treaty, one is progressive realization, which is a concept that's distinct for this particular treaty. And it says, like, if you have the right to education, for example, the treaty recognizes that it can't all happen all at once. So they recognize you can start with sort of free access to primary school education, and maybe secondary education and tertiary education will not be free, but you work toward making all education free. And key to that is, even though governments get sort of this pass, they don't have to do everything all at once. So they can't be discriminatory in working toward realization of those rights. So they can't say, okay, we'll make primary education free for everyone and secondary education we'll make free for boys. You can't do that because that violates the non-discrimination principle. There's also language about the right to work. There's language in the treaty about the right to family and family relationships, to food, clothing, and housing. The right to health, education, and culture are some other examples of rights in this treaty. Health is highlighted because that's the one area where we had some inroads with this particular treaty to talk about death penalty issues, specifically access to health care for people under sentence of death. So that opens a little bit of a door, not very widely, but gives us a little bit of a chance to talk about issues related to the death penalty for this particular treaty. And certainly we can bring up issues related to, food and clothing and housing in a penal situation. We just haven't had a lot of luck, but we'll continue to be persistent. The next convention or treaty that we'll talk about is the Convention on the Rights of Persons with Disabilities, looking at the intersection of disability and the death penalty. This is the newest of the big 9 human rights treaties. And again, very widely ratified. If you're familiar with the United States Americans with Disabilities Act, it's modeled after that act, which makes it kind of surprising that the United States hasn't ratified it. But there are some really interesting issues related to disabilities and the death penalty. Something that I think is really important to set for the groundwork on this particular treaty is the treaty recognizes that all persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. Now, you may have heard, and certainly we encounter people advocating for restricting the death penalty for certain populations. Like we've already seen, pregnant women shouldn't be executed and juvenile offenders should not be subject to the death penalty. Some people will argue that people with certain disabilities, like psychosocial disabilities or intellectual disabilities, should not be executed, should not be eligible for the death penalty. Now, people can make those arguments, and those are fine to make. Lawyers do what they need on behalf of their clients. But under this particular treaty, the treaty experts and the people who drafted the treaty feel very strongly about recognizing the legal capacity of all persons with disabilities. And what that means is they don't want disability to be a means by which people are exempt from punishment for their conduct. And so we don't make the argument in front of this committee that people with psychosocial disabilities or intellectual disabilities should never be sentenced to death. What we argue is that people with disabilities need support in exercising their legal capacity so that the legal proceedings, to be fair and to give them the right to a fair trial and to due process, they need to have more supports in place. They need to have legal representation with training and experience working with these people with disabilities. But they do not want to have sort of an overall exemption for people with disabilities based on their disability status, because in essence, that opens the door to reducing their legal capacity, to reduce legal recognition of their capacity as legal agents. And that's a really damaging thing for people with disabilities to make that argument. So that's a little bit tricky. I'll work with there's just one team working on disability issues, and we'll work with the team at Frederickson on those issues, but I think it's important for everyone to be aware of that as well. State party obligations under this treaty include access to justice. So it's important for people with disabilities to have fair trial rights and due process rights, et cetera. The next treaty we'll focus on is the Convention Against Torture and Cruel, Inhuman, or Degrading Treatment or Punishment. Again, very widely ratified, 173 state parties. And there are a lot of intersections between torture and cruel and inhuman degrading treatment or punishment and the death penalty. One caveat, however, is the definition of torture. If you look at the bottom bullet point, torture does not include pain or suffering arising only from, inherent in, or incremental to lawful sanctions. So a lot of governments that have ratified this treaty say death penalty can't therefore be torture. So we don't make the argument to this committee that the death penalty per se is torture, because this last bullet point kind of creates that loophole. But the definition of torture otherwise is severe pain or suffering. It can be mental or physical. It's intentionally inflicted for one of various purposes, or just because of discrimination by the government or a public official, or with the consent or acquiescence of a public official. So it might be, for example, that a means of execution amounts to torture. Or it might be that detention conditions could amount to torture, or it might be that a government uses torture to extract a confession that might then result in a death sentence. So state party obligations, the most important ones for our reporting purposes, are the obligation to train law enforcement and others involved with custody and interrogation, so that they don't use torture or other kinds of coercion to extract confessions or to extract evidence, and then excluding evidence procured through torture or cruel and inhuman degrading treatment, excluding that from trial, and then preventing cruel and inhuman degrading treatment or punishment. And while I've said that we can't argue that the death penalty per se amounts to torture, where we do have good inroads with this committee is under Article 16, which talks about cruel, inhuman, and degrading treatment or punishment. The committee accepts, we don't even need to advance the argument, the committee accepts as a given that the death penalty does amount to CID treatment or punishment. It is cruel, inhuman, degrading, even if we have to abide by the language that kind of seems to create a loophole for considering the death penalty to be a form of torture. So Article 16 clearly death penalty issues, the death penalty falls within that at a minimum. The next treaty we'll talk about is the Convention on the Elimination of All Forms of Discrimination Against Women. Again, fairly widely ratified. This is a treaty body we've just started over the past few years doing advocacy with to raise issues related to women, gender, and the death penalty. And we're becoming increasingly successful in raising these issues. The relevant language to look at is what amounts to discrimination against women. And we see in the treaty that women have the right to equality before the law, that state parties have an obligation to modify social and cultural patterns of conduct, to eliminate stereotypes and prejudices. And so all wrapped up in this is that when we're talking about death penalty issues as they affect women and other gender minorities, we talk about the process by which they're sentenced to death. And oftentimes there are components of discrimination within that process, whether it's the prosecutors and the language they use at trial, whether it's things that judges say or a jury might conclude, or whether it's the defense attorneys themselves don't have training in terms of bringing up mitigating arguments at sentencing about a woman's history of gender-based violence. And for example, overwhelmingly when women are sentenced to death around the world, they're sentenced to death for murder, and overwhelmingly it's for killing a family member, typically an intimate partner, typically in a context of gender-based violence. But in most countries, when they're considering self-defense as a defense, that defense has to, the threat to the person who uses lethal force has to be imminent. And oftentimes, because women are oftentimes not as strong as their spouses, oftentimes they will take action and use lethal force when their spouse is passed out on the couch or asleep. And in those contexts, this use of lethal force does not fall under self-defense as a legal defense. And so a woman can be charged with charged with murder, convicted of murder, and then at the mitigation phase of the proceedings, what would be relevant, but defense attorneys often don't bring it up, is the circumstances surrounding that conduct, and that those circumstances should take into account that history of gender-based violence that may have led her to engage in that conduct. Treaty-based mechanisms, generally speaking, they don't apply. These committees and this treaty language doesn't apply unless a country has ratified the particular treaty. And then each treaty itself, in addition to having the substantive rights that we've just taken a breeze through, sets up language setting up a committee, a treaty monitoring body made up of independent experts who interpret the treaty. These are typically law professors from all around the world who specialize in the particular rights falling under the umbrella of that particular treaty. So that's our audience for these reports we're writing. And these committees have regional geographic representation. They're not all from Europe. They're not all from North America. But these experts are our audience. These are people who have expertise in the particular treaty language. What they don't have is knowledge of what's happening on the ground. They don't have knowledge of the particular death penalty circumstances in the country that they're getting ready to review. And that's where we help bridge that gap. If you think of that cycle that I showed earlier on, we're helping to feed information to those experts so they can lock in their expertise and use that to influence the governments to pressure them to move toward abolition of the death penalty. These treaty-based mechanisms have a lot of different things that they do, these committees, but what we're going to focus on is the state reporting piece of it, because that's what these reports are for that are due in January. And again, just a reminder of which treaty body we're talking about and whether we have a report at the list of issues stage at this earlier stage or at the shadow report or alternative report stage. But you'll see that on the treaty bodies on the left-hand column, each treaty has its own respective treaty body or committee. And so the committee, the CEDAW committee is the committee that oversees the Convention on the Elimination of Discrimination Against Women. The Committee Against Torture oversees the Convention Against Torture. The Committee on the Rights of Persons with Disabilities oversees the Convention on the Rights of Persons with Disabilities, and so on and so forth. The only one that's a little bit weird is the Human Rights Committee, and it's like they got there first. And so the Human Rights Committee is the one that's in charge of civil and political rights. They got the name Human Rights Committee, even though all of these committees focus on human rights. It's just different areas of human rights. So this is the reporting cycle, and this is what we call the standard reporting cycle for the teams I've already communicated with. This is what I highlighted in our toolkit. The reporting cycle is pretty straightforward. There's a standard reporting cycle, and then there's a simplified reporting cycle, and I put on the board or put on the screen which countries are following the standard reporting cycle and where we are in the process. So the first part of the standard reporting procedure is that the state party, the government, submits its own report. It's like an audit or a self-audit where the government says, okay, here are our treaty obligations. Here's what we've done since the last time we met with you, the treaty body experts. This is all the good stuff we've done. Here's where we've had some struggles. Here's where we're making some improvements, etc. After that state party report comes in, then the committee looks through the report and will also look through information shared by civil society organizations like the Advocates for Human Rights and our partners, and prepare a list of issues. And this list of issues is kind of like an agenda. Like, these are the things we care about. These are the things that's kind of are raising concerns. So for the teams working on the Iraq CEDAW report and the Nigeria report on people with disabilities, the committee is getting ready to prepare that agenda, and we want to help shape that agenda. We want to make sure that death penalty issues are on the agenda as the committee prepares for its review. So that's where we are with those two reports. Is we have a state party report. The government has done its own self-assessment. Now we want to get our foot in the door and say to the experts, hey, when you're setting the agenda, be sure to talk about these issues. Be sure to ask questions about these particular issues. After the list of issues gets published, then the state party has a chance to provide a written reply. And when the state party provides a written reply, that's also a chance for us as civil society organizations to take another bite at the apple, to say, okay, we looked at what you, the committee experts, put in your list of issues, and we looked at what the state party said in reply, and here's some additional information, or here's where the state party reply was, skirting the issue, avoiding the truth, just ignoring things altogether. That gives us another chance to put information in front of the experts before they conduct their actual review. So for the team working on Sri Lanka, for the CEDAW committee, and Nigeria for the, I have Nigeria in two different places. I'll clarify that in just a moment. Nigeria is at the earlier stage, is at the list of issues stage. So I'm not sure if I missed something. That might be Zimbabwe that needs to be in that place, Zimbabwe or Kenya. One of the two. We're going to be at that later stage of the process where we have the list of issues, the agenda has been set, and now we're going to try to get our issues. That is Kenya, in fact. It should be Kenya for the Committee on Economic, Social, and Cultural Rights rather than Nigeria. Apologies about that. And so this is sort of our last chance before, at stage 4, there's a constructive dialogue. The government sends a delegation to Geneva. They have a 6-hour Q&A session where the committee experts ask lots of hard-hitting questions, and the government sometimes struggles to respond to those questions. There's a lot of back and forth where the committee experts share what they're concerned about, and the government gives its responses. And then a few weeks later is step 5 of the procedure, and this is what we're all waiting with bated breath for after the review happens, is the committee publishes its concluding observations, including recommendations for the government, saying, okay, here's what we're concerned about, here's what you're doing a good job with, and here are recommendations. When we talk to you next time, we want you to have done these things. So we really want to make sure that our recommendations, our suggestions go into the recommendations from the committee experts so that we can really leverage their expertise to push the government to, again, move toward abolition of the death penalty. After those concluding observations come out, then it's a few years of implementation. The government is supposed to be implementing, and that gives our partner organizations a chance to say, hey, you remember the Committee on the Elimination of Discrimination Against Women made these recommendations about women sentenced to death. Let's work together on getting those implemented so that next time around, when you go back to Geneva, you can be bragging about all the great stuff that you've done for this particular topic. So that's an overview of the reporting cycle. And that, again, that's the standard reporting cycle. There is also a faster reporting cycle that is, I don't know why my slides aren't advancing. There we go. The simplified reporting procedure. So the simplified reporting procedure starts with the committee setting an agenda. So the committee sends a list of issues, what they call a list of issues prior to reporting, to the state party and says, before you even go to the trouble of writing a report, here's what we care about, here's what we want you to share information about with us. And then the government submits written replies. And those written replies constitute or are a substitute for the state party report. So it basically skips that initial state party report step in the procedure. And for the teams working on Antigua and Barbuda, Barbados, and Jordan for the Human Rights Committee, and on Antigua and Barbuda, Botswana, Iraq, and Kenya for the Committee Against Torture, this is where we are. The committee is preparing to write up this list of issues prior to reporting for the government. And we want to make sure in that LOIPR, the committee includes death penalty issues and any other related issues on the ground that our partners might have or that our research might uncover. So we want to get in early on the ground to help set the agenda with those committees. Then the government gives its written replies. And after the government gives its written replies to the list of issues prior to reporting, then again, there's that constructive dialogue in Geneva. So for the Zimbabwe team, we already have the list of issues prior to reporting from the committee, and we have the government's replies. And now we're jumping in saying, hey, during that constructive dialogue, here's some relevant information for you experts to have at your fingertips. And here's some recommendations we'd like to see you making in those concluding observations. The rest of the cycle is the same as the standard reporting procedure. So death penalty issues, what issues are you going to look for? Common issues to include in your report would include whether the country, sort of on a matter of looking at the penal code or the criminal code, do they limit the death penalty to the most serious crimes? Most countries do not, but we also always want to flag that. Does the country have a mandatory death penalty? A mandatory death penalty is by definition arbitrary because it doesn't allow the court to take into account the facts and circumstances of the offense. Does the country sentence to death juvenile offenders? Does the country have the death penalty for people with psychosocial disabilities? Do they have appropriate supports and accommodations for them throughout the criminal legal process? That would also apply to people with intellectual disabilities. There may be fair trial issues related to access to counsel, quality of counsel, the training they receive. There may be issues relating to torture and cruel and inhuman degrading treatment to extract confessions or to gain evidence. There may be issues related to lack of impartiality amongst judges. We also talk about detention conditions for people under sentence of death. If we can't get specific information for people on death row, we'll talk generally about detention conditions in the country. Does the person have a right to appeal? What methods of execution are used? We typically only talk about execution methods if there's something specific about them that raises an issue about, for example, torture or cruel and human degrading treatment. So in the United States, we'll talk about the botched executions. But just mentioning that a country uses X method of execution, if that particular method hasn't been singled out as a problematic method, we typically don't talk about it in those circumstances. Gender in the death penalty, we try to talk about gender in the death penalty in every single report we do. Even if it's not for the CDAW committee, we're trying to integrate discussion of gender and the death penalty in all of our reporting. So please, for all of your teams, please do what you can to identify whether there are women under sentence of death in the country and whether your particular treaty, whether there are issues related to that. Are there women with disabilities who have been sentenced to death, for example? What do we know about their cases? So keep that in mind as you do your research and prepare your reports. Discrimination as well with respect to migrant and domestic workers is a topic that comes up a lot. Is there discrimination against people from different ethnic, religious, or linguistic minority groups? Discrimination against LGBTIQ plus communities, whether in the context of being sentenced to death for what we call an ordinary crime like murder, or being sentenced to death for consensual same-sex conduct. There's a handful of countries that do authorize the death penalty for consensual same-sex conduct between consenting adults. And then issues related to human rights defenders, whether it's attorneys or human rights activists who oppose the death penalty, whether they face any hurdles to doing their advocacy or persecution. I have a YouTube video that we created a few years ago that I've shared with the teams that I've sent out overall materials and templates to. This is provides a really good overview going into sort of a little bit more detail than I have just on the previous slide about death penalty issues for UN reporting. It's really helpful to get a better sense of what types of issues we talk about in a little bit more depth if you're looking for that. Writing the report itself, general guidelines for writing that report: use Microsoft Word, make sure you're using, we give you a template, so use that template, be sure to fill out that cover page. There's typically no page limit for most of these treaty bodies, but usually the reports end up being between 5 and 15 pages. Make sure that all pages are numbered and all paragraphs are numbered. Use footnotes, not endnotes, and please, 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 at this stage, don't use IBIDs or supras or any sort of internal cross-references in the footnotes, because we do spend some time potentially rearranging things, moving things around, doing some edits, and it gets really frustrating if we lose the reference from an IBID or a supra. So please just use full source citations for everything. Every sentence should have a footnote attached to it with a full source citation that we can use so that we can move it around. And then we'll modify the footnotes as we get closer to submitting the report. In terms of language, please use people first language. It's really important to view these individuals whose human rights are being violated as individuals. People are more than just their current situation. So we try to avoid terms like prisoner or inmate. We'll talk about people in detention, individuals in detention, people under sentence of death, also people with disabilities. So try to use that people first language in your reporting. It's fine to talk about LGBTIQ plus people if the context warrants. Our audience, I've mentioned this already, our audience are the experts, the treaty buddy experts who have expertise in the particular treaty and what that treaty means. They're our main audience. And again, so we don't want to sort of argue and present a lot of details about what Article 6, Paragraph 2 in the Covenant on Civil and Political Rights means. They know what that means. What they don't know is what's happening on the ground in Antigua and Barbuda about the death penalty, for example. Secondary audiences may include the government of the state under review. We want the government to read our report. We want them to see our criticisms and the issues that we identify. And the general public can also be another audience for our reporting, because a lot of our partner organizations will share these reports widely with their supporters and use them to educate journalists and so on and so forth. So there is this broader audience, but the primary audience, again, is the audience of treaty body experts. For those teams doing list of issues reports, As I've mentioned in going over the two different reporting cycles, the committee publishes a list of issues, or LOI, or if it's following the shortened reporting procedure, the list of issues prior to reporting, and that helps set the agenda for the committee's upcoming review. So our goal, if we're doing this reporting at this earlier stage, is to, well, two different goals: ensure our issues are included in the LOI that the committee publishes, and also potentially to gather information from the state party. We've had some really good luck, in particular, asking the committee to then ask the government for data about the death penalty. For example, we did a report a couple of years ago with the Committee Against Torture on Ethiopia. And at the time, we didn't really know anything about the status of women under sentence of death in Ethiopia. But at the list of issue stage, we got the committee to ask the government of Ethiopia, tell us about, give us disaggregated data about people under sentence of death, where they are, what crime they committed, et cetera. And lo and behold, they published they included in their response, they included an appendix that had a table of every single person under sentence of death in Ethiopia. And we found that there were 2 women. So asking for disaggregated data at the list of issues stage is really, really helpful, especially for countries where it's not entirely clear how many people have been sentenced to death, how many people are on death row, and the gender breakdown there. We always want to know, for women sentenced to death, what was the crime they were convicted of, what relationship they may have had to any victim or co-defendant. Sometimes there's a coercive control relationship between a woman offender and an intimate partner, for example, who gets her involved in committing criminal acts. And of course, sometimes she's accused of killing her intimate partner. In the case of women who are domestic workers, sometimes she's accused of killing her employer when her employer was abusing her, raping her, things like that. So there may be context there where we want to know what is that relationship. At the list of issue stage, we'll ask for that disaggregated data so we can try to tease out some of that information for governments who aren't necessarily very transparent about capital cases. The key documents you'll look at this stage for these list of issues reports, you'll look at the treaty, of course, as we've done that quick overview. You'll look at the committee's concluding observations from the previous review, if there are any. There might not have been a previous review. This might be the first time around. Then you'll look at the follow-up reporting from the last review, if there was any that's relevant to our issues. And then if there's a state party report and a Common Core document, you'll look at those as well. But it's pretty early on. There's typically not a lot already in the pipeline for these list of issues reports, but those are the documents you'll look at. And then the look back period, sorry for the chaotic nature of this slide, is going to be either when the previous concluding observations came out, or if this is the country's first time engaging with the treaty body, the date they ratified the treaty. So in that latter category for Nigeria ratified the Convention on the Rights of Persons with Disabilities in 2010, and this is the first time it's been reviewed. So we just look back to the date of ratification. For Antigua and Barbuda, again, just ratified the Covenant on Civil and Political Rights in 2019, so that's the look back period. For all of the other countries listed on the left-hand side, those are the dates of the previous concluding observations that they had for their respective treaty bodies, so that's going to be the relevant look back period for your particular country. We have given you, or we will give you soon, a template. Please use that template and you can fill in the number of the session, the mechanism, the dates of the session. I should have given you, if I've already sent my transmittal email to you, you'll have the link for the session so you can plop in all that information. But please do use the template as you're doing your reporting. For alternative reports, again, those are the reports that are later in the process. That's Zimbabwe, Sri Lanka, and Kenya. Those are our 3 alternative reports at this stage. This is, again, leading up to this committee's constructive dialogue with the government of the state under review, where the government sends a delegation to Geneva. After that constructive dialogue, the committee publishes its concluding observations and recommendations. And our goal here is to make sure our issues are included in the constructive dialogue during that 6-hour Q&A session, and also, most importantly, in the concluding observations, that the committee experts will make recommendations that are relevant to our issues and that will help move the ball forward toward abolition of the death penalty in the country that the committee is reviewing. So our key documents are, of course, the treaty and the committee's concluding observations from the last review and the state party report. Those are less relevant, though, because we're farther along in the process. So what's most relevant for these alternative reports or shadow reports are the list of issues or list of issues prior to reporting, and then the state party response or reply to the LOI or LOI-PR. Those are the primary documents you're going to focus on for these particular reports, and we're going to try to hook our issues to what's in the list of issues and the response to the list of issues to the extent we can. If not, we're going to still try to wedge it in, but the sort of primary structure that we're going to use is the LOI and the LOI-PR for framing our arguments. If you go to a particular treaty body webpage for a session, you'll be able to see any of the relevant documents that are available. This is just an example for the Committee on Economic, Social, and Cultural Rights. Their upcoming session is February 10th through the 28th. And as you scroll down, you'll see the consideration of state reports. Each country has its own little plus or minus sign, and you can find all the relevant documents as you click the pluses to get that information. So you can go down to Kenya, and you can see for Kenya, if you click the plus, you'll see the state party report that also had an annex. There's a common core document. There's the list of issues, and there's the reply to the list of issues, and then information from civil society organizations for the list of issues. That means the earlier reports that were submitted. You'll see if you go to that page, you'll see a report that we submitted with our partner organization, ICJ Kenya, at that list of issues stage for this particular report. So the session webpage is really useful in terms of getting all the relevant documents that are in front of the committee for that particular review. So for the look back period for these 3 countries that are at the alternative report stage, it's when we submitted our list of issues report to the same treaty body. In other words, we already engaged with all 3 of these treaty bodies at the previous part in the review cycle. So all we're looking back at is since the last time we talked to you, which was probably like a year ago, maybe 3 years ago, I guess 4 years ago for the Human Rights Committee. So since we last talked to you, here are the developments and here's where we are. So you don't have a big period of time to take a look at. You're going to, for Zimbabwe, you're going to look at the last 4 years. For Sri Lanka, you're going to look at just since 2023 when we submitted our previous report. Same thing for Kenya and the Committee on Economic, Social, and Cultural Rights. That's the look back period. So you don't need to go back because we've already engaged in this part of the cycle. You don't need to go back to the date of the ratification of the treaty or the previous concluding observations. If we hadn't, then you would look back. Again, we have an alternative report template. It's very similar to the list of issues template that you have. Please use the template as you prepare your report. The substance of the report, what we'd like you to do is primarily is to provide on-the-ground information that might be of interest to the committee experts, provide recent, current information on our issues that could be relevant to the committee. We also want to, in the report, provide a fact check on anything the government says in response to the list of issues or the list of issues prior to reporting that might be incomplete or incorrect or shade the truth regarding our issues. Or maybe they just ignore something the committee asked for and they just don't provide the requested information. So we can highlight omissions and non-responses to the LOI or LOI-PR on our issues. Again, we're not going to talk about all the issues, just things that are connected to the death penalty. And then the substance of the report will also propose recommendations or solutions. It will propose things that we'd like to see in those final concluding observations. In terms of good practices, trying to frame each issue, use your target recommendations or your target questions to frame your arguments and organize your report. Here's what the government says, here's what the law says, here's what the penal code says, and then here's what's really going on. Here's what's actually happening. You can definitely use examples or stories to highlight problems that might be gaps in the law or barriers to implementation. A lot of times when we do advocacy on women, gender, and the death penalty, we know that there are women under sentence of death, but we can't find information about their individual cases. So if we find one case, we may spend a lot of time talking about what we know about this one case and how this represents a broader pattern globally, and that it may reflect a pattern as well with the other women under sentence of death in that country. Don't go into a long procedural history about what's happened with this particular committee. The committee experts know that because that's what they do. Don't do a lengthy discussion of the substance of particular rights. Again, the committee experts know all that. You don't need to do a lengthy legal analysis. We don't want the tone of a legal brief. You also don't want vague recommendations or vague questions. You want to be as specific as possible. So here's an example from a report we submitted to, I think it's the Committee Against Torture about Somalia. Might be the Human Rights Committee. But you can see in these paragraphs how we frame the issues. So this is at the alternative report or shadow report stage, but you'll see how paragraph by paragraph we frame this. Paragraph 5, in the list of issues prior to reporting, the committee asked Somalia to provide information, blah, 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 and requested blah, blah, blah. So just like a couple sentences summarizing what the committee asked for. And then the next paragraph, in response, here's what the government said in its reply. It says this, it says this. So that's paragraph 6 is just, 3 sentences summarizing what the government said or what the government asserted. And then paragraph 7, 8, and so on are providing that information on the ground. Here's what's actually happening. They're continuing to carry out death sentences. They carried out this many executions. Here's what we know. And then there are, sometimes people are executed within days of a court's verdict and so on and so forth. So the meat of the report, the real substance of the report is going to be after you've done that framing. Here's what's in the list of issues or the concluding observations. If your report is at that earlier stage, here's what the response is. And then here's all this information that we have to share. Some general principles about SMART recommendations. This is particularly relevant for the Zimbabwe, Sri Lanka, and Kenya teams who are preparing recommendations, not just questions to ask. Remember your audience. Your audience is treaty body experts. They do have some time to go into some detail. You'll all have, as a point of reference, some concluding observations that you can look at so you can see the level of detail they go into typically. And they issue their recommendations in writing. So you can reference specific laws that may need to be amended or specific provisions in the procedural code, whatever is relevant. So keep that in mind. And always connect issues to solutions. So make sure that you, depending on what the posture is of your report, make sure you present a solution or a recommendation or a question to address each issue or problem you mentioned. So if you go through the body of your report where you're presenting all of that information, make sure you have questions or recommendations that would help address those issues you identify. You don't want to have sort of dangling information out there with no action item for the committee experts. Similarly, you don't want to have an action item that doesn't have an explanation in the body of the report. So make sure there's a connection between those recommendations or suggested questions at the end of the report and the substantive information you're giving in the heart of your report. SMART recommendations, I'm guessing you're all familiar with this acronym, but it's good just to have a reminder. You want recommendations to be specific, measurable, achievable, relevant, and time-bound. The time-bound part, typically we don't need to do in the context of this advocacy because it's usually the implicit time-bound is the next time you're reviewed by the committee, which is supposed to be every 3 to 5 years. But next time you come up to the committee, make sure you've implemented these recommendations. Working with partner organizations. We have partner organizations through the World Coalition Against the Death Penalty. And I really encourage you, if we have a partner organization that we're working with on this report, please open the lines of communication as early as possible. They can help sort of set the agenda and set priorities for what's really going to be worthwhile to emphasize and talk about in the report. They may be able to share firsthand information or reports or links to credible news sources on the ground. So please open those lines of communication as soon as possible. But also keep in mind that some of our partner organizations just might not have a whole lot of information to share. One of our partner organizations in the Caribbean is the Greater Caribbean for Life, and they do have a network of attorneys throughout the region, but their attorneys sometimes don't have that information. They're busy representing people who might be sentenced to death. So be patient. If they don't have information, you'll rely primarily on desk research. If they do have information, then work with them to try to get as much of that included in the report. All of your reports are going to be based a lot, primarily on desk research, supplemented by whatever our partner organizations can get to you to augment the desk research that you're doing. And I think it's also a good practice if time allows to circulate a draft outline or a draft of the report early on to your partner organization to see what they think, to get their input. I will plan to sort of finalize the drafts that I get on December 6th and get them sent out before the winter holidays so that our partner organizations have time to take a look at them before those reporting deadlines come in early January. So with that, I think I have managed to leave about 10 minutes for questions or for me to talk in more detail about topics if people want me to talk in more detail. December 6th is the deadline. There is, of course, if your team needs another day or two, please reach out to me early on. It's fine if a few teams need to slip by a couple of days, but if everyone's slipping, then that's going to make my, December kind of miserable if everything comes in late. So please try to get things in by the deadline if at all possible. If I've already sent your team an email, that will include a link to our UN advocacy chapter that includes, if you're like me and you prefer to receive your information more in written format, that is a good tool for you to use for that as well. So with that, I will stop sharing my screen and open it up for questions. You are welcome to write out the questions or just unmute yourself, and we'll take it from there. As you're coming up with questions, I'll emphasize one thing that I think bears repeating or bears emphasizing. If you're working at the list of issues stage, your primary goal is going to be to get your issues on the committee's agenda. So rather than focusing on recommendations at the end of your report, you're going to focus on suggested questions or suggested requests for information. So think about it in that way, like what information would be most useful. And in a lot of cases, you'll find doing your desk research, okay, the most recent official data about death sentences is from 2021. So a request, a suggested request for disaggregated data since the last review, because the look back period is relevant, like since the last review, how many people have been sentenced to death? How many people have been executed? What are the crimes for which they were sentenced to death or executed? Can you disaggregate that by gender, disaggregate it by nationality, and by relationship to any victim, relationship to any co-defendant, so that we can really tease out more information? That's been a really helpful way for us to gather information. Let's see.
I have a question.
Go ahead.
I was wondering how soon the recording for this training will be posted. So I'll definitely want to go back to some of the slides.
Yes, and I'm happy to send out the slide deck as well, but yes, we will. I just need to get it, it's going to be saved to my computer, and then I need to have my colleagues upload it to our YouTube channel. And then I will send out that link, and I'll send out, when I send out the link, I'll also send out the slides as well, if it's easier for you to just go through the slides.
Thank you.
And for those of you who are interested, I guess I should have mentioned this early on, but we do have Minnesota CLE credit pending. I need to look at my colleague's email. Let's see. Okay, she says, and I'll put this. Okay, the event code I'll put in the chat, but that's for the on-demand. For the live webcast, the event code is 517974. Let me put that in the chat. And we're also applying for on-demand credit. So if one of your colleagues wants to watch this video through our YouTube channel, you need to click through a registration platform just so that we have a record of attendance. But we have applied for on-demand credit as well for this, and I'll put that in the chat as well. There we go. And again, those are applied for, but not yet approved, but we typically don't have any problems approving these. I guess while I'm waiting for other people to come up with questions, to give you a little bit of sense of how this fits into the broader puzzle, we do these reports, and then these reports give us the opportunity to ultimately, when that review happens in Geneva, we try to, if we're able to be physically present in Geneva, we will participate in briefings with civil society organizations, meeting with the committee experts before that review happens. Sometimes there's some hallway lobbying that we do during the actual review if we see them asking a question and the government's giving sort of a shifty response. There are also opportunities, more limited now than they were a few years ago, for virtual participation in those briefings. So we try to bring our partner organizations to Geneva when we can, so that they can be the ones to do those briefings, or at least to record a statement for the committee experts to view, to help sort of focus their attention on particular relevant issues. I'll give you an example. We have been working with a partner organization called the European Saudi Organization for Human Rights. This is an organization of Saudis who are in exile from Saudi Arabia, working on human rights issues in Saudi Arabia, including the death penalty. And the Committee on the Elimination of Discrimination Against Women just reviewed Saudi Arabia's human rights record. And while our colleagues from ESOHR weren't able to travel to Geneva, they did record a statement. We collaborated with them on reporting both at the list of issues stage and at the alternative report stage. And then we collaborated with them on preparing an oral statement, which they did a video recording of and submitted that to the committee. And then the committee came back with an email like requesting additional information. So we pulled that together, gave that to the committee, and the committee's concluding observations just came out, and they were really good. They had really specific language about women sentenced to death in Saudi Arabia, including migrant workers. And our partners were just really, really thrilled with that, the results of that advocacy. And similarly, we've had really good responsiveness from the experts on the CEDAW committee, because they hadn't really paid attention to this issue until a few years ago when we started doing this advocacy, and they've described it as eye-opening. They said it's really helped them to expand the purview of their reviews, so that now whenever there's a country that has even a single woman under sentence of death, that committee is basically expecting us to get information to them. And similarly, we are now integrating issues related to women, gender, and the death penalty in our advocacy with all of the treaty bodies, because they care about it. All of the treaties have language about non-discrimination, and that includes gender-based discrimination. And so it's really exciting to see that it's not just the CEDAW committee, but all of the committees that are really perking up their ears when we start talking about issues related to gender and the death penalty. There's been some great research by our partner organization, the Cornell Center on the Death Penalty Worldwide, based at Cornell Law School, about women sentenced to death around the world, and what we know and how little we do know about the circumstances that lead to those death sentences. They just published an article, a scholarly article, reviewing the trial transcripts of women sentenced to death here in the United States. And I think their findings were like 96% of women in the United States who have been sentenced to death have experienced some form of gender-based violence in their life stories. And in most cases, it's pervasive, ongoing gender-based violence, whether it was sexual abuse when they were children or whether it was other circumstances. It's just overwhelming, the pervasiveness of gender-based violence for these women who come to be in contact with the law. And I really commend, whether you're working on a report for the CEDAW committee or whether you're just trying to get your head around issues related to women, gender, and the death penalty for a report that's not for the CEDAW committee, their research has been really, really helpful in helping us formulate our information we give to the treaty bodies and the recommendations and the questions we want them to ask.
So I had a question, especially as we're going to doing our desk research. Do you have any, recommendations on websites we should go to, especially when it comes to news? I know, for example, if we're looking at, individual cases, we might be, digging through news sources, trying to find information. Based on previous deep dives, their recommendation on ones we should look for, or ones to say, no, this is our equivalent of The Onion, do not use that.
Thank you for that question. If you look at your template, we offer some suggestions, and the checklist also offers some suggestions of sort of go-to, like consistently reliable sources and so on. But it's also a question, if you're a team that's working with a partner organization, it's a great thing to ask for, like, country specific, what are the credible or more credible sources of news, or just, you know, collect a bunch of links and say, hey, we found this reporting, is this credible, can we rely on it or not? That's why it's really important that we have, you know, when we do have it, we have partner organizations. Of course, you know, the big credible international news sources like the New York Times, International Herald Tribune, Agence France Presse, the Associated Press, Reuters, all of those are fine. But a lot of times, especially for the smaller countries or countries that just don't get a lot of coverage, you're going to have to dig around. And so do your digging, and you can run things by our partner organizations or run it by me if you have questions. And also, like, look at, you know, if it's like a blog, you know, we tend not to cite blogs, but if it is a blog that seems to have credible information, try to find out who the author of the blog is. And again, reach out to the partner organizations, see what they say, see what their response is when you say, okay, we found this blog that explains this. They might have a better source of information as well that might have more credibility. You know, we're pretty flexible about things, but you're right. We don't end up citing the Onion or the equivalent for Antigua, Barbuda, or Iraq or something like that. I would be happy to schedule follow-up calls with any of the teams that think that would be helpful. You can, you know, reach out to me for the teams I haven't yet emailed, the materials and the template, etc. I think I just received a few sets of emails this morning from your pro bono coordinators. So I'll try to get those emails sent out as soon as possible by the end of the day tomorrow, if not sooner. But if you do want to set up a meeting for your team to have a call with me, I'm happy to do that. Just let me know. Or if you want to just follow up with questions via email, that's fine too. I'm here at your service to help your work run as smoothly as possible. And again, I really thank you for all of your hard work that you're going to do. And thank you for volunteering for this project. I know some of you have a lot of experience already. Some of you, this is your first time. I hope you have a great experience, and don't hesitate to reach out if you have any questions or need a helping hand, need me to help, you know, re-explain something. I'm happy to do that. And we're just really thankful for your willingness to help us with these projects.
Thanks, Amy.
And with that, we're past the hour. Thank you again for your time, and I'm going to stop the recording and end our call. Thanks again, everyone. Bye-bye.